questions either by the emails that are on the screen now or via the chat. We'll see what we can come to, which ones we can get round to answering at the end. Just before we start, I'll just mention a little bit about Withers and Rogers, which is that we deal with all technologies, patent prosecution and some litigation too. We've got 6 offices, 3 of which are shown on this map: London, Paris, Munich. And the reason for highlighting those is that they already some of the most important locations for litigation, but could become even more so under the new regime. So before we get onto the new system, we're just going to mention the existing system that people should be aware of. At least most people in this call probably will be. So the existing system for European patents, which we've had now for some decades, since the 1970s. And that is pre-grant, we have this single patent office, the EPO, which has central examination and granting process. We emphasise there it's not an EU institution. The reasons for emphasising that should become apparent later on, but there's no direct link to the EU. So, for instance, Brexit wasn't relevant to the current system. There are multiple countries covered by by European patents which are outside the EU. So it's granted in one place, great, but as people might be familiar with, post-grant it currently gets a bit more complicated in that you need to nationally validate the patent in all countries of interest, and then those national validations almost become separate patents and kind of live independent lives. In particular, should they need to be enforced, they will have to be enforced through separate national courts. And again, those validations include EU countries and also non-EU countries. So far, in all those decades since, we've only had one departure from that normal regime, which only involved Liechtenstein, which is not a country most people think about. But as you were about to see, we are close to a situation in which we're going to have a departure from this norm of separate validation for each country and separate court actions for each country. Just before we start with what we're looking forward to in the future, I just mentioned from this slide a couple of pieces of terminology. One is we talked about this phrase, national validations, and that's how we would describe the national parts that are conventionally validated after an EP grant throughout the rest of this talk. And also just mention, for those familiar with the EPO's examination granting process, one part of that process that will come up later is the last part of that process, just before grant, which those who have encountered this before, there is a notice of allowance from the EPO with a text that they intend to grant, and then that text needs to be approved via various actions, including claim translations and fees, and then grant follows. That's what we often refer to as a sent one free communication. I'm bringing that up now because it has some relevance to the rest of the talk. Right, that's enough from me. Over to Joanna for the brave new world of the Unitary Patent package.
And good morning, good afternoon and good evening, given the huge time zone difference that I can see in our audience. Thank you for joining us. So, where are we going in the future? Well, the Unitary Patent, or more correctly, the patent with unitary effect, is a brand new patent right arising from an EU initiative. So, as we've already hinted at, it can only cover EU member states. Given that it is EU only, self-evidently it can't then extend to the UK or to other non-EU member states such as Norway, Switzerland or Turkey. And this new patent right will be accompanied by a new patent court, the Unified Patent Court.
Yeah, hello from me here in Paris, and I'll be speaking to you more about the Unified Patent Court later in the presentation. And this second part of the Unitary Patent package, the Unitary Patents Court, or the UPC as we'll refer to it, will be the only court that's able to deal with matters relating to the infringement and the validity of these new unitary patents that are issued. It'll also have some potential jurisdiction over some validations of the traditional kind that Russell's talked about, but we'll go into more detail about that in due course. Ultimately, in due time, all patents granted by the EPO for the Unitary Patent contracting states will be litigated before the Unitary Patents Court, whether they're unitary patents or not. But again, we'll go into more detail on that. So back over to you, Joe, to talk a little about the timeline for the introduction of this system this year.
And here we have a graphic trying to illustrate this. So where are we now? Well, for the system to come into force, we needed several things to happen. And as of the 18th of January, which is why we're talking to you now, when Austria ratified the legislation, everything's in place except for the final step. Now, that final step is the ratification of the legislation by Germany. Once Germany ratify, the system will come into force on the first day of the 4th month following ratification. So how much notice we have of the what we're going to term go live date will depend upon the day of the month when Germany choose to ratify. Now, Austrian ratification, which we've already had, allowed the provisional application phase to come into force. Now, this is essentially a setup period. It's always been expected to last at least 8 months. Because German ratification will trigger a 4-month deadline for the system becoming operational, Germany will intentionally delay this final step, their ratification, until preparations for the court in particular, but also the patent, are sufficiently far advanced that the court can bring itself into operation within that 4-month window. So essentially, Germany are holding off their ratification to allow the processes to be put into place for the UP and the UPC to operate. However, German ratification is expected sometime in the summer. And on the timeframes we're then looking at, with the 4-month window being opened up, we're expecting the first unitary patents to be granted this autumn, possibly October, more probably later than that. Given that the entry into force is required by the legislation on the first day of the month, we're expecting this to be either the 1st of November or the 1st of December. It might slip to 2023, but there's the political will to get this up and running this year. The ratification will start what is termed the sunrise period.
Yeah, and let me talk a little about the sunrise period and what its effect is. Remember this term because we'll talk more about it later in the presentation, and the sunrise period is fairly important to the issues that you need to start thinking about sooner rather than later, and we'll give you more detail on that. But essentially, the sunrise period is a preliminary period of time which enables applicants to take preemptive steps to have their portfolios ready for when the UP system finally goes live at the end of this sunrise period. So the 8 months is there to allow all the systems to be put in place, and this sunrise period essentially allows applicants and patent owners to take the preliminary steps they want to have in place before the system actually goes live. So it's the first time you can formally file requests concerning the Unitary Patent package, and we'll elaborate again in later slides on exactly what that involves in practical sense. But for now, I'll hand back to Joe to talk about the territories that this unitary patent is going to cover.
Yes, so in some senses, I'm going to cover the basics. Now, we've already mentioned that the unitary patent is a single patent right, and it has the potential to cover most of the EU. At this stage, it can protect the 17 countries that are listed here, and it will cover more as more members ratify. We're expecting Ireland, Romania and Greece to join up in the near future, possibly even before the go live date, which would bring us up to 20 at that point. What we do know, however, is that certain countries have decided they don't want to join up to the system. And so Spain and Poland at this time have said that they're not interested in being part of this. We don't know if that will change, but that's the way things are now. Now, you'll recall that the current system is such that you file a single European patent application at the EPO, where it's examined and all being well, eventually accepted for grant. at which time you select the countries that are of interest and bring the granted patent into force in those countries. Validation, as Russell has already explained. And what we get is a bundle of national rights that are then treated independently from that point forward. With the new system, if you want protection in countries other than this initial 17, you can either opt for traditional validations across the board, or you can combine the unified patent, the unitary patent, with validations in those countries that are outside the system. Now, why is this important? Why do we want to be thinking about this? Well, the right will cover the EU as a single market. And even with the current 17 member states, as opposed to the 2025 that we could have, that's more than 300 million people with a GDP of 13 trillion. As you might imagine, that makes it a huge market on global scales, and so something we all need to consider as part of our filing strategy. So, given the timeframes around taking action now, we're likely to enter the sunrise period in the summer. Now is the time that we need to start talking to you. You need to start talking to us about what markets are currently important to you. And in view of that, are traditional European validations the way we want to keep going, or do we want to introduce the unitary patent? Could a mixed approach be appropriate? And hopefully by the end of this talk, we'll have given you some of the basic tools to start making those decisions, asking those questions of us, so that we can iron out these issues and come to some strategic decisions. Now, this is just a quick visual of the protection that's available. So the red on the left is what we're used to. It's the European Patent Convention. And so all the member states and all the extension states. In the middle, in the dark blue, is the current scope of the unitary patent, so the 17 signatory states that we're talking about. And on the right, in the pale blue, is the potential coverage of the unitary patent, so 25 out of 27 EU member states. Thinking in terms of combining protection, the middle and the right represent the current and potential future coverage of the unitary patent. The remaining countries in red are what can then be mapped on to this protection. So you could think of the unitary patent as a streamlining process to obtain 17 of the countries in one hit, leaving fewer validations to add to this in the traditional way. Now, Russell, I know you had some comments on how this could impact the unitary effect.
That's right. And as Joe has said, you could choose at the end of the process to have a combination of a unitary patent covering the 17 countries, or potentially more in the future, and some validations which you might add, like the hole in the middle of the blue, which represents Switzerland, potentially the UK, slightly to the north. Now, the different types of right you'll have there have different pros and cons, so they're fairly well known, but a vulnerability of a unitary patent is that it can be centrally revoked or invalidated. But one of the benefits of it, on the other hand, is that you can potentially have injunctions and damages awarded across many countries in one go. Now, there are also differences in how they can be handled as an item of property as well, which we'll illustrate slightly briefly with some points on the next slide. Now, in terms of them being an item of property, a unitary patent is owned. That's perfect. is owned as a single item of property. So in very simple terms, if you want to sell it or assign it, it has to go as a single piece of property and all the territories go with it at once. However, it is possible to license a unitary patent on a country-by-country basis. So in short, there is some flexibility in how you license it country by country. But as an item of property, it's a unitary item of property, which has to be assigned as a single item. Now I'm going to hand back over to Joe to discuss some of the procedural aspects of this unitary patent system.
So now I'm going to move on to how things work. Good news, pre-grant there will be absolutely no difference to the current European Patent Office system. This is entirely a post-grant change. Post-grant, if a unitary patent is required, you request what we call unitary effect at the EPO. You have to do that within 1 month of the date of grant. So the first thing to note is that this is a much shorter deadline than the 3-month validation period that we're used to. So decisions around validation will need to be made sooner, and ideally instructions provided when providing instructions for responding to the notice of allowance, the communication under Rule 71.3. In terms of when this will start and when we can begin actioning this, any application that's pending at the go live date, so this autumn on the expected timeline, could become a unitary patent. Now this means that we'll be receiving notices of allowance soon, which could ultimately become unitary patents. And at this stage, as in right now, it's plausible that with delaying mechanisms, we could delay grant for long enough to open the unitary patent up as an option for you. Finally, I should be clear in and around the system that you can't double up protection by seeking protection in a member state via the unitary patent and also a national validation, so France, for instance. But as we've mentioned earlier, a blended approach is possible. So to give a very specific example, let's say you or your client wanted protection ultimately to be in France, Germany, the UK and Spain. Well, the UK isn't in the EU, so can't form part of this system, and Spain have chosen not to join. So you have the option of validating in all 4 countries using existing mechanisms to create 4 national patents that are completely independent of one another. Or you could validate in the UK and Spain and seek EU unitary effect to get your protection in France and Germany, where you'd get 15 bonus countries. Now, we'll talk in a little while about the cost balance ratios of all of this, because obviously that's something that you're going to have questions about, you're going to want to know.
So I think a really interesting point about what Joe's just explained, and it's one that's important to remember, that this unitary patent is not a replacement for the existing system, but it's actually an additional bit of flexibility in how you choose your post-grant strategy in terms of national validations and or grouping those with a unitary patent. So this is offering a little more flexibility, does require a little more thinking at the post-grant stage, but overall it's giving users of the European patent system more choice in how they obtain protection in various countries after the grant of their European patent.
Yeah, thanks, Russ. That's absolutely true. Now, given what I've said about this being a post-grant change, it won't surprise you that the filing fee, the EPO, the prosecution costs and the grant fees are the same as they have always been. Further, the draftsman of the legislation considered the applicants when they were preparing that because they didn't include any legal provisions for the EPO to introduce an official registration or validation fee. So we have costs up to grant that are identical to where they always were. And we then need to look at where's the balance between traditional validations, with attorney costs, translation costs, renewal fee costs, against the new system. And the unitary patent could be significantly cheaper than obtaining European validations. This will obviously depend on the number of countries in which you or your clients normally validate and the translation requirements attached to those. But there's scope for significant savings and much broader protection with that. Now, one feature of the unitary patent system is that we will need to file translations, a single translation. There's a desire, and I think it's a reasonable one, for all member states of the unitary patent system to have available to them a translation of every granted patent in their national language. And so to obtain unitary effect, there will be a requirement to file a single post-grant translation. Now, that carries costs with it that we need to consider. And of course, we've just said, depending on the countries that you have traditionally chosen to validate in, they've always been translation costs. So only needing a single translation may very well be cheaper than the national validation route. But it's something that we need to consider and that we have added into all of our modelling. Now, these translations aren't actually going to be used in the way you might expect. The aim is ultimately to obtain these national language translations via a machine translation system. And the EPO have been working on one with Google, but they don't yet have full confidence in this machine translation system. And so until they do, we'll be required to file the single translation with our request for unitary effect. Now, the fact that we have to file it with the request for unitary effect is important because we've discussed you only have a 1-month deadline post-grant for doing that, and that's a tight deadline. The translation that we need to file will be one of a translation of the application into English if proceedings were before the EPO were in French or German. Or, and this is where it gets interesting, if proceedings were in English, a translation of the application into any other official language of the Union. The translations that we file will be fed into the machine translator to help improve the system. And that system will remain in place for at least 6 years and ultimately until either the EPO deem that the machine translations are of sufficiently high quality that the requirement can be lifted, or a total cap of 12 years is reached. We believe that translation costs are likely to be in the range £900 to £3,000, depending on the complexity of the specification and the language selected. From our perspective, this is a formalities requirement, and so we'll look to reduce costs where we can. So, for instance, if there are translations in existence, for instance, a Spanish language translation from a corresponding filing in Mexico with the same specification, or if the patentee wishes to validate separately in Spain, so needs to prepare a translation there, we will reuse that translation where we can to fulfill this requirement. If we're working from first principles, we'll find an inexpensive language to file in. Russell, I think you had some thoughts about this.
Yeah, thanks, Joe. So I think what's interesting about this is that we've got an initial period essentially during the training of the EPO Google machine translation system where there is a cost of this translation in the post-grant phase, but a benefit of that training that should materialize in due course is that the cost of that translation will no longer apply. And so there's potential for even greater cost savings in the unitary patent route because there's no longer any cost of the translation that Joe's just been discussing. Back to you, Joe.
Fingers crossed for the machine translations. So the other component of the post-grant costs is the renewal fees. And as can be seen from this graph, which plots in orange the unitary patent annual renewal costs. It's important that this graph is actually just renewal costs, it's not total costs. Against the blue, which is the cost for renewals in all 17 member states. The unitary patent is significantly cheaper than maintaining in all member states. But we all know that very few applicants would file 17 validations under the current system. It's far more common to validate in a small number of countries, which we've shown here, giving examples of 2 countries, Germany, France, and for Germany, France, the Netherlands and Italy. What we found from our analysis is that the balance point is 4 countries. Now, I'm talking at this stage in the round. I'm not talking about purely the renewal fees. I'm talking about also building in local attorney costs and translation costs. And what we found is that if you only want to validate in 2 countries, it will always be less expensive than a unitary patent. In particular, if you use W&R to validate in France and Germany, our ability to handle this directly through our French and German offices ensures significant savings. 3 countries, the renewal fees themselves are likely to be less expensive, but when you add translation costs and attorney costs, that could often will tip the balance in favour of the unitary patent. And finally, as you say, the balance point is at 4 countries. If you're interested in 4 countries, it will generally be cheaper to seek your validations through the unitary patent to request unitary effect instead of using the traditional means. Now, having set out the fundamentals of the unitary patent as part of this system, I'll hand over to Russell to discuss the Unified Patent Court.
Great, thanks very much, Joe. So, yeah, as we said earlier, the second part of this unitary patent package is the court, which is going to have jurisdiction over the unitary patents that start to come into existence. So the court's going to have a central division. This central division is divided by subject area. And as we said before, the seat, which is essentially the administrative centre of that central division, and the court is going to be here in Paris. Also, the subject matter that's handled in Paris is going to be the domain of electronics and software. There'll also be a part of the central division in Munich, which is going to handle mechanical subject matter. And the first time around, when the unitary patent system was first established, the life sciences and chemistry part was going to be handled in London. Now, in the meantime, the UK has left the European Union and it's decided to leave also the unitary patent system. So the life sciences and chemistry subject matter is somewhat drifting at the moment. It's not been decided where that will be located. There's a political discussion to be had amongst countries about where that might be centred in future. But in the meantime, to avoid that discussion holding up the putting in place of the system, we understand the intention is that that will be distributed between the existing locations of Paris and Munich. Now, also, there will be a series of local divisions, which can be created in individual countries, and a series of regional divisions, which can be created by groups of 2 or more participating countries. There'll also be a Court of Appeal, which will be located in Luxembourg. So we've got lots of different locations for this court. So it raises a question of forum shopping. What might be the reasons for choosing different locations and who might be able to influence that? Well, the reality is, because of the way the system is created, in an infringement action, it's the claimant who will essentially hold the cards. They can choose a local or regional or central division based on a few considerations. If they want a local division, it can be in any contracting member state where either the infringement occurred or the defendant is based. The central division may be a default if there is no local or regional division where that infringement occurred. It's worth bearing in mind that across the European Union, there's generally a common currency. If sales are made online, then it may be possible to essentially detect for infringement with a purchase in a state of your choosing. So if you're trying to launch an infringement action, there may be a lot of flexibility about which place you want to choose. Some of this can drive a choice of language. Generally, there's likely to be enough choice of a local or regional or central division to ensure that the English language is used. If that's desired, there may be users of the system who prefer that the procedure happens in English, if that's, for example, your business language. It also raises a question of what's been termed rocket dockets. Essentially, this can be jurisdictions where local judges in a certain country might start to be particularly patentee friendly, for example, or the inverse could happen. Now, the intention of this system is that it is a common court distributed across different geographies. So there are mechanisms in place to try and ensure uniformity of the decisions that come out. And so the powers of the president of the court of first instance allow the control of the local division panels with 3 legally qualified judges from the pool of judges from the contracting member states. There are some restrictions on this. It's generally only based on nationality, but that provides a mechanism to help to ensure uniformity of the decisions coming from the different locations that this single unitary patent court is distributed across. Joe?
And that's actually one of the things that I really like about this system. They've clearly thought about the need for it to be harmonised, the need for decisions to be of the same standard. And by sharing judges from a central pool, hopefully that will really help allay concerns around unreliable decisions. So yeah, I think this is a really brilliant way to deal with the fact that we have such a diffuse legal system being created.
Quite right. It's a good way to de-risk the system in that sense. So let's take a little look at the rules of procedure before the court. We won't go into huge detail here, but this is just an introduction. So the intention for the procedure is it will be heavily front-loaded. So this means there'll be a lot of written submissions prior to any hearing taking place. There's likely to be some limitations in presenting new facts or arguments at a late stage. Now, those of you who've been involved in European Patent Office oppositions might recognise some of those things. The EPO opposition procedure is increasingly based on early written submissions, and it's increasingly hard to get later changes to your case or additional evidence submitted, and especially on appeal. And the UPC system is modelled slightly on the EPO opposition process, and so the experience is likely to be very similar. Now, cases are going to be quite actively managed. This is something that has some of its origins in a court called the Intellectual Property Enterprise Court in the UK, which our firm has some significant experience acting before. But the idea here is that the presiding judge will be quite proactive in saying what evidence, further evidence they might require, which witnesses they might want to hear if witnesses are involved, etc. So they're going to drive the procedure and drive the parties to try and make sure that this proceedings runs smoothly and quickly. And this is also driven by the fact that the oral hearing will generally be aimed to last only one day and to take place within a year. So the judge only having a day to hear a whole case is going to want to be very sure that the discussion on that day is very relevant to what the judge and the panel need to hear to be able to decide this case within a day. So things like disclosure and discovery and cross-examination of witnesses are potentially available. The judge has complete discretion in ordering or potentially refusing either of these if one of the parties or the other wants to see those included. So what we're going to look at next is a transitional period and something called the opt-out. So this transitional period has been put in place because this is a new court, essentially. The long-term aim for both unitary patents and these traditional EP validations that we've talked about, which are in UPC states, is that they all come under the jurisdiction of the Unitary Patent Court. Now, the Unitary Patent Court is always going to have jurisdiction over unitary patents. For EP validations, there's a decision to be made there, and we'll come on to that. During this transitional period, your EP validations can be litigated before the Unitary Patent Court or national courts. And because this is a young court, the Unitary Patent Court is a young court, then it was desired to give users of the European patent system the option to opt out of having this new court have jurisdiction over their EP validations. So let's be clear, if you go for a unitary patent, it'll always be under the jurisdiction of the Unitary Patents Court. But if you choose not to go for a unitary patent and you opt for national validations, you do have the option to essentially refuse the Unitary Patent Court having jurisdiction over your validations. This is available during an initial period of 7 years. Now that period is the period within which you can make the requests. If you make a request, it can remain in place for the life of your patent, but it is intended that over either the initial 7-year period, but that can be extended to 14 years if it's deemed necessary. By the end of that period, the Unitary Patent Court will have complete jurisdiction over everything that comes through the European Patent Office in the unitary patent states.
One of the things that actually interests me about this, there's been a lot of coverage in the relevant journals around people having concerns about the initial reliability of the UPC, etc. But anecdotally, we've spoken to a lot of people who see this as a real opportunity and who are actually excited to get involved in the Unitary Patent Court at an early stage as patentees to try and help shape it. and develop it so that it's good for patentees, it's patentee friendly, and some of that enthusiasm is really infectious, and it's really great. So
yeah, I think that's absolutely right. Early users of the system are going to have the opportunity to actually live the experience, give feedback through various channels of people who are representing. I'm sure the court will be listening to how it's working. And so early users will really be able to feed into how it develops and how case law develops, of course, which is what's going to define how the court works in future.
And it's a system that everyone will have to use, ultimately. So
that's right. So there's a balance of getting used to what you'll be using in the future at some point. But yeah, there's a decision to be made on who's going to be using it first. Let's go on to the next slide and take a look at the decisions that need making in the near term. And some of these decisions will last in the long term as well. So when you're looking at choosing your European protection, there's the top decision. Essentially, do you use the European Patent Office at all? There is still the option, and there will always be the option, of filing individual national patents in any of the chosen countries. If you do choose to use the European Patent Office, you've then got to decide whether you obtain a unitary patent or not. If you don't use the European Patent Office, you end up with national rights, and they are under the jurisdiction of national courts, as is shown in the square in the bottom left corner of the screen. So let's say we decide to use the European Patent Office. There's then this decision, are we going to obtain a unitary patent or are we not? If you decide yes, so that's taking the right-hand route here, then you have a unitary patent right, and that is under the unique jurisdiction of the Unified Patent Court. You may decide not to. As we've said, the option remains to choose individual validations. So then there's a decision to be taken. Do you want to take the do nothing approach, which is going straight to the bottom here? Now, this is important to understand. If you do nothing, then you will have a bundle of national rights, and they're in fact under the jurisdiction of both the national courts and the Unified Patent Court. And so someone could potentially, for example, launch proceedings against you before either the Unified Patent Court or the national courts in the relevant country. If you file your opt-out during this period, if you opt out to the Unified Patent Court's jurisdiction, then again, you end up in the bottom left-hand corner, you've got a bundle of national rights, and they're under the jurisdiction of the national courts. So this is an important decision tree to consider when thinking about your overall strategy. Essentially, which box do you want to end up in? Which box are you comfortable ending up in? And then, as we can see, there are a number of routes you can take to decide whether you're going to be dealing with unitary rights, whether your rights are going to be under the jurisdiction of the Unified Patent Court, or whether you want to keep your rights purely national. And those decisions will depend on the industry that you're working in, the geographies that you cover with your IP rights, and then how you might consider launching any litigation. And these are all questions that we'll be trying to help lead you through in future presentations. Okay, at this point, we're going to move back onto this sunrise period. So remember, we said, keep this in mind, because this is the period that's coming up later on this year. And this is where we need to start making decisions about real actions that we take to decide what rights are going to be in place. So as Joe's explained earlier, this is going to start 3 to 4 months before the overall system goes live. And it's triggered by Germany deciding to deposit their ratification. It's ready, they can do it when they like, but they're planning to do it in an organised manner once every stakeholder in the system is ready for it to go live at the chosen time. So this ratification and the beginning of the sunrise period has at least 4 effects here. So we will have legal certainty over what the actual date of go live will be for the Unitary Patent Package. In this period, you can file opt-outs if you are deciding to opt out of the Unitary Patents Court having jurisdiction over your rights. Requests for a unitary patent can be filed Now, these are going to take effect when the sunrise period finishes and the actual system is in operation, as long as grant hasn't occurred before that point. And what the EPO has already put in place preemptively is a new procedure which will go live during the sunrise period, which means that you can defer grant in this period to ensure that you can benefit from a unitary patent when the actual system goes live. And this also has a caveat. We've got to make sure that the text intended for grant has not been approved before the sunrise period begins, to ensure that this is an available option for you. So this is where we were talking about there are potential notices of allowance, these Rule 71.3 communications that are going to be issued very soon, where the deadline for responding to those needs to be monitored quite carefully with regard to when Germany chooses to deposit its ratification. Joe, what are your thoughts on these points?
Well, again, what interests me here is, I suppose, again, it comes down to people having thought through the system. We all know that this has been a fairly long road, and 4 or 5 years ago, when we were last looking at this starting, there was no mention of the final point on this slide, the EPO procedure to defer grant. And the fact that they've introduced that with the reboot of the process, I think it's very welcome, because it makes it much easier for us to control the fact that the application won't accidentally grant before the go live date. If the go live date slips, well, okay, but we'll know that we've got this request for deferral in place. And so the unitary patent is definitely going to be possible within the live window. So anyway, I think you have a pretty good slide to show what you've just been talking about.
Yeah, so here it is in pictorial representation. So you've seen this slide earlier on. What we've now added to this are these newly allowed applications represented by this green arrow, where you might be receiving Rule 71.3 communications. And the key, as we've described, is whether the deadline for responding to that notice of allowance, Rule 71.3 communication, falls within the sunrise period, i.e. after German ratification happens, or before it. So essentially, when you receive the Rule 71.3 communication, we can't actually be sure which side of the German ratification the deadline is going to fall until the ratification actually happens. So if the 71.3 deadline falls after German ratification, you can get a unitary patent by using this new EPO deferred grant option. So in that sense, you're safe. If it doesn't, and you're interested in a unitary patent, then we need to know that, so that we can take action to delay the deadline for applying to that Rule 71.3 notice of allowance. So before the sunrise period, we can't take advantage of this official delay period that the EPO has put into place, but it only goes live in the sunrise period. So if you've got 71.3 communications issued now or in the near future, and you're sure you want a unitary patent, then we need to take other actions to try and make sure that your deadline for response falls within the right window of that sunrise period. Come March to April this year, it starts to become uncertain as to whether we will need to do that or not. And then later than that, during the year, it becomes increasingly likely that your deadline for response is going to fall after the beginning of that sunrise period. So the point at which you approve the text with that response is really the key. And what this means is that right now, there's a little bit of risk and uncertainty around when that actual German ratification occurs. And the sooner you can have thought about whether unitary patents are of interest and whether we need to be taking any action, the better, because then we can make sure that we're helping guide you through that process and make sure that the options you want are available for you. So thanks, Joe. And yeah, I think we're ready to move into a question and answer session now. And I'm going to hand back over to Russell Barton to lead that.
Thank you, everyone. Thank you for the questions. By all means, people can put hands up as well, or we might come to them in person, but we've got quite a few questions already in the chat.